Good morning, everyone. Welcome to this session of the Tax Diploma course in Direct Taxation. Um, I'm happy to meet all of you. I know there's been a while since we have had the sessions. So we're going to continue the discussions we have had before. This session is about continuing the discussion on the differences between revenue expenditure and capital expenditure. We had a number of discussions in the previous session on the same topic, and we're going to now continue on this topic today as well. To begin with, I noticed that we already have a few participants, so maybe we should just jog our memories collectively, and we should ask, what are we trying to do in this session? So, can I ask a quick question to the participants? And the question is, just give me 1 second, please. Sorry, just give me 1 second. Yeah, sorry for that. We begin our discussion today by reviewing the foundations of why we are talking about the difference between revenue expenditure and capital expenditure. And in order to do so, can someone tell us why this difference is important and the context in which we are talking about this difference? So anyone, you can raise your hand or you can write on the chat box. But let's rejig our memories here. It's important that we don't discuss these kind of things out of context, right? We don't discuss it in isolation. If we do that, then we won't be able to get a hang of what the structure of income tax is. So let's begin with that. Why are we discussing the differences between revenue expenditure and capital expenditure? This is critical and important for anyone dealing with any tax matter. Yeah, so it's important. Let's see. So, do we have people who can just respond? I mean, you don't have to respond in any kind of elaborate manner, but just give me a sense of what you might be thinking. Yeah, quickly, please, because I want to go ahead. Just give me a sense. Just give me like a few sentences or a few words. That's fine. But I don't want to start off on a topic where we are still unclear about the foundations. Yeah. Surely there's somebody who can say something about this. Yeah. Why are we talking about the differences? Why do you think that this difference between revenue and capital expenditure is important? That's all I want to know. So it's not a very difficult question. And in fact, we covered it in our previous session. Yes, we have a response. Good. Finally, I was able to get a response out of you. And that is saying that items on account of capital are not deductible or at best amortizable or depreciable. Items on account of income are usually completely deductible. That's correct, that. And also to put that in perspective, if an item of expenditure is deductible, then it reduces your income for purposes of income tax, particularly your income under the head business income. If that item is not deductible, then the only way it can impact your tax return is if it is depreciable, in which case you can deduct a certain proportion of that capital expenditure from your corporate business income for that year. Notice I am now talking about two important things, which is one, that the idea of deductibility, the idea that income tax, the nature of income tax is such that it is on a net rather than a gross basis. You are allowed to make deductions against any kind of revenues that you get. That's one. That's one important point you should remember. And the second important point we should remember is that the discussion we are having of the difference between revenue and capital expenditure is a discussion not in an abstract way about income tax, but in a more particular way about income tax head of taxation called business and professional income. It is under that head that this distinction between capital expenditure and revenue expenditure becomes important. So you should keep that in context. Nancy Jane has also said something similar. She said tax on revenue expenditures deductible in the years it is incurred. That's correct. And the deductions for capital expenditure are over a number of years, provided that those deductions are allowed, those kind of deductions, the deductions over capital expenditure are allowed. And that's actually the subject matter of our discussion today. Um, so far, we have discussed a number of English cases because English common law is important in any discussion in Indian tax law. So far, we have discussed a number of cases in coming from England, but we have also discussed towards the end of our session the Honda Seal case, which is an Indian case, Indian Supreme Court case, and we had a quite an elaborate discussion on the difference between capital expenditure and revenue expenditure in that case. But today we're going to continue this discussion and we're going to give you a few more cases. The following is my agenda for today. Right? My agenda for today is to go over a number of Indian cases in this area. Same distinction, revenue versus capital expenditure. Um, I will make you, in that process, I'll of course give you an overview of what the case is about. But in that process, I will also ask you to read the some excerpts from the judgments. And we'll ask you to analyze it for me and ask you some questions. The purpose of asking you to read those judgments, and we'll do that together in today's course. The purpose for doing it is twofold. One, I want this is a the PG diploma in tax law. Unlike any other tax course or any other course you might have done elsewhere, is a course that is meant to make you understand the intricacies of the law, right? So we are looking at it as if a law student is looking at these kind of cases. And therefore, it is very important that we go through case law in quite some minute detail. Following on from that purpose of this course, when we go through the case law, we will also go through the typical problems with legal analysis. It's particularly important here. When students come to a course like this, especially students from outside the legal system, as in people who haven't studied the law formally in their professional lives, they tend to believe that the law on various points is certain and determinative, that you can actually determine what the law is. Neither of those things are true in many cases. And we learn, therefore, through this course to appreciate the ambiguities in the law and particularly how to address those ambiguities, how to make sure that we work with those ambiguities. This is a law specific way of looking at things, and you will not get this elsewhere. So it's important that we work together on this and understand that, right? So today's mandate is to do the Indian cases on revenue versus capital expenditure. One, that's the first mandate. The second mandate is to understand and appreciate what legal analysis means in the context of case law. That's something that we need to figure out and understand properly. And finally, we'll also we'll give you one hypothetical. I want to make you work through an hypothetical and see how you apply the principles that we have studied so far, right? So that's the mandate for today's session, and let's start off. Before I begin, I also want to remind my students that this time we have our next session during the week. So I think I've been given to understand that it's on Thursday of this week, 7 to 9 p.m. This coming week. So this coming Thursday. It's important because usually we have classes on weekends, on Saturdays. But because next Saturday I'm busy, I'm not available. We are having a class on Thursday, 7 to 9 p.m. Please make a note of that. I know that you've been informed of this already, but I just wanted to remind you about it. All right. So now let's start off on our topic, and I'm going to share my screen. And as usual, when I share my screen, I'm going to ask one of you to just confirm that you're able to hear me and also able to see me and the screen. Yeah, or at least see the screen. Right. And please make sure that when we're doing this, that you also have access to your course materials, note 21 onwards, because I'm going to ask you to refer to that in a second. Yeah. Okay. Uh, Please do let me know if you can see this and see the screen, see the PowerPoint presentation, and you're able to hear me as well. If you somebody could just put that on the chat box, that'll be great for me. Great. Thank you very much. Yeah. Okay, so today's about revenue versus capital expenditure, and we start with a very interesting case, right? And this case is called Sharp Business Systems versus CIT. It's a Delhi High Court case, and it's a case where the question was, in fact, all of the cases today are going to be dealing with non-compete payments, right? Payments for something called non-compete. And the question here was whether a payment made by a company towards non-compete fee was a capital or revenue expenditure for tax purposes. Yep. And um, first question would be, why would a company pay uh, money towards non-compete fee, and what is a non-compete fee? Let's start with that. Um, let's start with that. What do you understand by non-compete fees, and why would anybody pay a fee for that? Yeah. So let's see. Anybody on the chat box that would like to talk to me about it? Yeah. Anyone? So the question is this: we are now talking about one company paying another something called non-compete fees. And maybe I should give you some background. I should give you a business context. This usually would arise where um, one company buys a business from another company. A buys a business from B, and A then tells A enters into a non-compete agreement with B. Why would that be the case? Nancy has says for not to compete in a similar industry, and she's right. And what that what she's saying is that if I buy say A buys a business from B, now A has bought B's business and is going to continue that business, but A is a bit worried that B might compete against A in the future, and so A enters into an agreement with B, paying B a certain sum of money to make sure that B does not compete uh, against A for some time. Now, so basically, let's say that in the Sharp Business Systems case, uh, somebody had bought a business from L&T, I think, and then they entered into a non-compete agreement with L&T for 7 years. And they said that L&T should not be competing with the SSC for the next 7 years in that business. Why 7 years? Why can't it be indefinite for all time? Why should there be a time limit? Anyone? Why should there be a time limit at all? Any reason? Yeah, let me see if somebody has an answer. One second. Very good. That is given the right answer, which is that. Excellent. That, yeah, Section 27 of the Indian Contract Act says that. In fact, Dutt and Nancy both have given good answers, right? Dutt has given a legislative answer, and Nancy has given a constitutional law answer to it, but both are correct. The Indian Contract Act, Section 27, restrains says that in fact, Section 27 of the Indian Contract Act says any restraint on trade is will make that contract void. But the courts, Indian courts over the years have interpreted that to mean not any restraint, but only unreasonable restraints. The word unreasonable is not in the legislative language, interestingly. It is there, it is a gloss on the legislative language by the Indian courts, which is an interesting thing. It's an example of how legislation, the phrases and words of the legislation, and the impact of the legislation can be in some ways leavened out and moderated by the courts. And the reason the courts have moderated it is for the very reason that Nancy is talking about, which is that that our people's right to practice any trade or profession should be protected, but those rights, there can be reasonable restrictions on those rights under Article 19, and therefore what we have a situation where the any reasonable restraints on trade are protected, and therefore you can have, say in this case, 7 years, you can have 5 years, you can have a few more years of a non-compete agreement. Great. So we'll go back to our non-compete example. So whether a payment made by a company towards non-compete fee was a capital or revenue expenditure for tax purposes, and um, the if it were to be a capital expenditure instead of revenue expenditure, then would that payment be depreciable under Section 32 of the Indian tax legislation of 1961? Now, the court determined the expenditure as capital expenditure. Right? They said it's capital expenditure and not revenue expenditure because it's about ensuring that the uh, the kind of profit earning capacity of the business is maintained. Right, my capacity to earn profits requires that my competitor is prevented from competing with me. And they also said that this expenditure would not be depreciable under Section 32 because it's a right in rem and not right in personam. Sorry, it's a right in personam and not a right in rem. Now, there are so many interesting issues swirling around in this case, so we'll have to look at this case. And if you go to note 21 in your course materials, you see Sharp Business Systems versus CIT, and um, the court deals with the capital versus revenue issue in a kind of a peremptory manner. It says that, look, the expenditure on non-compete was no doubt, I'm talking about the first paragraph, no doubt that the amount is to ensure a certain position in the market by keeping out L&T and applying the test indicated in Empire Jute Company, Alembic Chemicals, coal shipments. This court is of the opinion that the deduction cannot be claimed as revenue expenditure. It clearly falls within the capital field. They mention the case law, and then they don't mention in what way they applied it. It is presumably the fact that in this case, it doesn't result in any kind of enduring advantage or asset of the sort that is required it does result in an enduring advantage or an asset of the sort that's required for capital expenditure. It is not merely maintaining the profit making apparatus of the business, and therefore it's capital expenditure. And then they ask question, If it is capital expenditure, can it be depreciated under Section 32? And I want you to take a look at Section 32. So please, if you could just go to Section 32, and I'm doing it here. I got the text in my hands, and I hope that all of you are either following it on your screen, or you have a Bear Act in your possession. Section 32 um, says this. Um, in respect of depreciation of buildings, machinery, plant, or furniture being tangible assets, know how patents, copyrights, trademarks, licenses, franchises, or any other business or commercial rights of a similar nature, being intangible assets, owned partly or wholly by the SSC and used for the purposes of the business or profession, the following deductions shall be allowed, and you don't have to worry about the rest, but there are some deductions allowed. So, Section 32 section says deductions are allowed with respect to these things: tangible assets, intangible assets. Tangible assets are buildings, machinery, plant, or furniture, and intangible assets are things like know how, patents, copyrights, trademarks, licenses, franchises, or any other business or commercial rights of a similar nature. And then the quote says, "Look here, your agreements. It looks like this is something that cannot come under Section 32, and it talks about right in personam and right in rem, and it says this is a right in personam and therefore not depreciable. This is what I want the class to do. Now, see, this is what you have come to the course for, which is that this is not an accounting focused course. It's not a philosophical focused course. It's a law focused course, right? And so here you see already very interesting application of some concept of law, which I think had its origin in Roman law, which is the difference between right in personam and right in rem. I want you to go through the excerpt that I've given you in the course materials and to explain to me what you understood this right to be, right in personam and right in rem, and why did it make a difference in this case. So I'm going to repeat my question and my task for the class. Go through the excerpt that I've given you. It's only a couple of pages. Note number 21. Don't Google, don't do all of those things. Don't go to any other place. Just read that excerpt and tell me what you understand by the difference between right in personam and right in rem. And why did that make a difference? That difference. Why did that have an impact in this case? All right, so I'm going to give you 10 minutes. I'm going to come back at 9:35 and I want an answer as soon as I come back, right? Note 21. Please be ready with your answer. What is the difference between right in rem and right in personam? And why is that making a difference in this case? Okay, 9:35. All right, I'm back, and um, someone is going to help me with this. So I already see that Nancy has put out a chat, and is anybody else? I did hear somebody talking. Is somebody wants to talk first, or shall I just read out Nancy's chat? Let's see what she's saying. In case of the intangible assets mentioned in Section 32, the court has analyzed that such assets give the owner a right against anyone and everybody for an indefinite period and transferable in nature. Whereas when it comes to a non compete agreement, the right is only against one individual or company. Um, just give me 1 second, please. Sorry. Just 1 second. Yeah. So the court has analyzed that the kind of assets that are mentioned under Section 32, I think that's where Nancy was going with this, are such that in those assets, the owner has given owner of that asset gets a right against anyone, against the world, which is right in rem, and for an indefinite period, and that those rights are in that asset are transferable in nature. Whereas when it comes to a non-compete agreement, the right is only against one individual or a particular individual or company for a definite period. And such a right is not transferable or alienable, and hence it does not fall under the category of intangible rights mentioned under Section 32. Therefore, we can say, Nancy is saying, we can say that the intangible assets under Section 32 reflect a right in rem, uh, and the non-compete agreement is a right in personam and hence not depreciable. Excellent analysis, Nancy, and I just want to make sure that the rest of the class is on the same page. Um, Yes. So when it comes to Section 32, and Section 32 says depreciation is possible for tangible assets, and they're given a number of tangible assets. Remember that even for tangible assets, they're talking about specific things: buildings, machinery, plant, or furniture. And so please remember, class, that if you don't fit into any of these categories, even if you have bought a tangible asset, you can't depreciate it, right? And so there's lots of case law about that as well. And then you come to intangible assets, and you have this know-how, patents, copyrights, trademarks, licenses, franchises, etc. But also any other business or commercial right of a similar nature. And the court is interpreting, this is where we come to the legal part of it, right? The court is interpreting what it means to have a business or commercial rights of a similar nature. And they're trying to say similar nature. So we'll go back to what came before that. And they say they notice that in all of these things, patents, copyrights, trademarks, and licenses, etc., are referring to what they call as a right in rem, which is basically that you, as Nancy put it, that it's a right where you get it against the entire world and you can enforce it. It's transferable, and so they're looking at kind of the nitty-gritty of what that right in rem would mean, and they're saying these the rights envisaged in 32 clause 1 clause 2 are rights in rem and not rights in personam, and your non-compete agreements are agreements which are right in personam. They're only granted as a right against one particular person, in this case L&T, and they're there only for a certain period of time, and they're not transferable. They're not traded on the market or anything like that, and therefore they're not depreciable under Section 32. Now, what's interesting about this case is what should have struck you as well, I suppose, when you were reading this case, is that from the taxpayer's point of view, this expenditure is a bit of a tragedy, right? Because it's not deductible as revenue expenditure. Um, Presumably because non-compete agreements don't result in anything in an asset or an enduring advantage. And not only is it not deductible, it's also not depreciable. and it's not depreciable because of a distinction made between two different kinds of assets. That distinction is not there in so many words in the statute, but the statute is being interpreted to make that distinction, right? And it's interpreted because it says it gives you a number of different kinds of assets and then followed by business or commercial rights of a similar nature. And by analogy, the court is saying if you look at all the previous assets that came before this phrase, business or commercial rights of a similar nature, you will notice that all those assets have this common property, which is that they are right in rem, right in personam are basically referring to different kinds of assets and rights in different kinds of assets, and they are of Roman law origin. And it's interesting that that difference, commercial difference, is making an impact on how we understand the implications of tax law, right? And this is area, one example of the deep connections between concepts in private law, commercial law, and concepts in tax law, right? So that's where we are. Now, before I go any further, anybody has a question or anybody has a comment or anybody wants to ask me anything about this case, I'll just briefly stop here for one bit. Let's see, is anybody else here? You can, of course, raise your hand or you can make a comment. I don't think I saw anything so far. All right. So then I'll go back to the case law. The next case is a case called CIT versus Ingersoll. None of the cases we're going to discuss today are from the Supreme Court. They're all from different high courts, and therefore they are, in fact, they differ from each other. Now, CIT versus Ingersoll is a Karnataka High Court 2014 case, right? And in this case, again, the question was about a non-compete agreement, and it was about some software system that was being bought, and then the question, and then they gave a certain sum of money to one of the employees, and because they didn't want that employee to compete against them. And so they gave him a non-compete fee payment. And the question was whether this non-compete payment was depreciable under Section 32. Now, here the court stated that a non-compete fee vested a right in the SSC to carry on business without competition, which conferred a commercial right to carry on business smoothly. And they said this is capital expenditure, but they then said when once the capital expenditure is incurred, the said right is to be held to be capital in nature. Consequently, the depreciation provided in Section 32, Clause 1, Clause 2 is attracted, and the SSC would be entitled to depreciation. So in this case, the Karnataka High Court has partly agreed and partly disagreed with the Delhi High Court in the Sharp Business Systems case. The agreement is that this is capital expenditure, right? And the disagreement, though, is that even though this is capital expenditure, this is subject to depreciation under Section 32. And I want you to go just scroll. This is note 22. Commission of Income Tax versus Ingersoll, Rand. And if you go down 1, 2, 3, 4, 5, 6, the sixth paragraph. I'm hesitant to give you a page number because it looks like my page numbers and your page numbers don't match. So I'm just giving you the paragraph number. Sixth paragraph that begins by saying Section 32 has been widened. So I'm just going to read that out. Section 32 has been widened by the Finance Act of 1998, whereby depreciation is allowed on intangible assets acquired on or after 1st April 1998. Now, as per Section 32, Clause 1, Clause 2, depreciation is allowable in respect of know-how, patents, copyrights, trademarks, licenses, franchises, or any other business or commercial rights of a similar nature. The assets which are included in the definition of intangible assets includes, along with other things expressly enumerated, any other business or commercial rights of a similar nature. Therefore, the expression business or commercial rights of a similar nature need not answer the description of know-how, patents, etc., but must be of similar nature. The fact that after the specified intangible asset, the words business or commercial rights of a similar nature have been additionally used clearly demonstrates that the legislature did not intend to provide for depreciation only in respect of specified intangible assets, but also to other categories of intangible assets, which are neither feasible nor possible to exhaustively enumerate. Right? And the word similar nature is a significant expression. It means not identical, but corresponding to or resembling to in many respects, somewhat like or having a general likeness. Um, and then they go on to say in the next paragraph that um, what they are looking at, therefore, in the enumeration of the previous assets is what is the nature of those assets, and they say that it is necessary to notice that the intangible assets enumerated in Section 32 of the Act effectively confer a right upon an SSC for carrying on a business more efficiently by utilizing an available knowledge or by carrying on a business to the exclusion of another. Uh, Non-compete right encompasses a right under which one person is prohibited from competing in business with another for a stipulated period. It would be the right of the person to carry on a business, but for such agreement of non-compete. Therefore, the right acquired under a non-compete agreement is right for which a valuable consideration is paid. And the object of entering, I'm just skipping a few lines. The object of entering into a non-compete agreement is also the same, that is, to carry on a business in a more efficient manner. So this is how the logic the code exercises its logic. It says the object of acquiring a know-how, patent, copyright, trademark, etc., is to carry on business against rivals in the same business in a more efficient manner, or to put it differently, in the best possible manner. The object of entering into a non-compete agreement is the same, that is, to carry on business in a more efficient manner. On payment of a non-compete, the payer acquires a bundle of rights, such as restricting receiver directly or indirectly participating in a business, which is similar to the business being acquired, from directly or indirectly soliciting or influencing clients or customers of the existing business, etc. The word commercial is used in Black's Law Dictionary as related to or connected with trade and commerce in general. Commerce is defined as the exchange of goods, production, or property of any kind, buying, selling, and exchanging of articles. Uh, right, now this is a critical line. A right by way of non compete is acquired essentially for trade and commerce, and therefore it will also qualify as a commercial right. So you notice here the difference, therefore, between how Ingersoll is interpreting it and how Sharp Business Systems are interpreting it. Sharp Business Systems focused on the idea that the intangible assets enumerated in Section 32 have the quality of being a right in rem, whereas in Ingersoll, the courts have focused on the enumerated assets having the quality of basically a, a, a right of carrying on, enabling a right of carrying on business or commerce, and so in a more wide manner. So if the asset is available to carry on business it's useful in a business or commerce, and here they use the word in that paragraph, the ability to carry on the business in a more efficient manner. So if it's useful, if it's used for, as long as it's those assets are used for trade or commerce, they will qualify as a commercial or a business right. So the Ingersoll case is given a wider, a more liberal interpretation of what a commercial or a business right is as compared to the Sharp Business Systems case. But in both these cases, interestingly, they are using reasoning by analogy. They're just looking at what those enumerated intangible assets are and then trying to figure out reason from there and trying to say, well, this of a similar kind. One focused on the right and rem quality of the enumerated assets, and the other focuses on the utility of those assets in business. All right. So, are there any follow questions or comments on this? Um, Dutt has asked a question. Did the joint venture feature affect this case? Sorry, Dutt, I'm not able to understand what you're saying. Do you have a, do you want to just explain that a bit more? I didn't understand that point. You asked a question, did the joint venture feature affect this case? So I'm not sure what you're asking. Um, No, not really. So, no, the joint venture medium has not affected the decision. They're really focusing on what might be the nature of the intangible asset that entitles somebody to depreciation. In the shop business case, they say it's a right in rem quality. Whereas in the other case, in the Ingersoll case, they say no, it's a quality that it's useful for business. It makes a business more efficient, right? And that's what they have been focusing on. Excellent. We have come to 9:52. I should give you a 10-minute break. We'll come back after 10 minutes, and I want to do a few more cases with you before I give you something to work on. Yeah, so I will come back in 10 minutes time. Thank you. Okay, we are back. Now, we have seen two cases so far, and in both cases, a non-compete agreement. Sorry, um, just give me a second. Um, we have seen two cases so far. The CIT versus Ingersoll case and the Sharp Business Systems case. And in both these cases, the non-compete agreement resulted in a capital expenditure. And it was in one case, in the Sharp Business Systems case, there was no depreciation allowed, whereas in the Ingersoll case, depreciation was allowed because it was considered as an asset for purposes of Section 32. Now let's look at some other variations. Yeah. So you go to the ITO versus Smart Kim Technologies case, which is the next case. Again, all the cases that are being discussed here are High Court cases. This is note number 23, and the Smart Kim decision is from the Gujarat High Court, and this is 2016 judgment. So all of these are fairly recent. I mean, as far as tax law goes, fairly recent judgments, and we don't have a finality yet on what's happening. And again, this is a similar case where a business was being acquired, was being purchased, and then the person from whom the business was being purchased was given a certain amount of money as non-compete fees. And this question was here again, the same question in the non-compete payment was revenue expenditure, capital expenditure in the first place. And the court stated here that the payment of rupees 6 crores made by the SSC as non-compete fee was an allowable business expenditure of a revenue nature, right? So they allowed it to be deducted, um, and so that's really interesting because now we are going against the first part, which is that it's not both Sharp Business Systems and Ingersoll had said that it's not deductible as revenue expenditure, and here they have said that it is deductible. Um, what they do, the if you when you I want you to go through the decision a little bit, and what happens when you do it is you will be shocked to realize that this is one of those decisions where the court will give you a long passage from other judgments. And then after that, without much application of reasoning, come to a conclusion, right? So you notice that the court, if you, this is a note 23, the court begins by talking about a purchase followed by a non-compete agreement, and then it says the following question of law was framed: whether on the facts and circumstances, the ITAT, the income tax appellate tribunal, was right in holding that the payment of rupees 6 crores made by the SSC as non-compete fees to VBC Industries Limited was an allowable business expenditure of a revenue nature incurred by the SSC. And then you have competing arguments by the council, and then there is a long the court begins by saying we have heard learned counsel appearing for both sides, we have gone through the judgments relied on by the learned advocates, and then it goes through a long 2-3 pages of quoting from various judgments. And then it says at the end of it that in the present case, the non-compete fees is for 5 years, and it is the expenditure incurred primarily and essentially related to the non-competition of the transferor company against SSC in the same business, which constituted the profit-earning apparatus of the SSC. Therefore, in view of the aforesaid decision of the Honorable Supreme Court, which are the decisions I've talked about previously, and we are of the opinion that the view taken by the tribunal is just and proper and is not required to be interfered with. And the tribunal was right in holding that the payment of rupees 6 crores was to as non-compete fee was allowable as revenue expenditure. So you see, not much of application of reasoning in this case. But the reason why this case is given to you is because the discussion of case law, those in the italics, those long discussion of case law is actually quite important. It gives you a very interesting insight into the nature of legal reasoning. So it's actually something that I think we should spend a little bit of time on. It, some part of it you might find a bit tedious because I'm going to now discuss the case law that is cited by the court. But it's really important for the class to follow me on this, because what it does is the discussion gives you an insight into the nature of legal reasoning on the one hand, and then the idea that if legal reasoning results in an uncertain and ambiguous state of affairs, how do we go forward? What do we do? Right. So let's look at these questions through a discussion of the case law here. So if you see the discussion case law in italics, the discussion on this distinction between capital expenditure and revenue expenditure begins by going back to that famous English case that all the judgments, both Indian and English judgments, talk about, which is the uh, Lord Cave in Atherton versus British Insulated and Helsby Cables Limited, where I'm just going to quote what the law lord has said. When an this is what is capital expenditure. When an expenditure is made, not only, sorry, one second here. One second. Yeah. When an expenditure is made, not only once and for all, but with a view to bringing into existence an asset or an advantage for the enduring benefit of a trade, I think that there is very good reason. And then in brackets, in the absence of special circumstances leading to an opposite conclusion, for treating such an expenditure as properly attributable not to revenue but to capital. Notice the various interesting and perhaps frustrating things about this paragraph, right? The way Lord Cave has gone about defining capital expenditure. Lord Cave gives you a sort of a definition of what capital expenditure is. It says when an expenditure is made not only once and for all, but also with a view, with a purpose, to bringing into existence an asset or an advantage for the enduring benefit of a trade, then it is considered as capital expenditure, unless in the absence of special circumstances leading to an opposite conclusion. So one might be tempted to think when you read this kind of test that this is not really an operational a test that can be operationalized, because it's a test that says something is X unless we think it is not X, right? But this is uh, the nature of legal argument in many domains, right? Certainly in any domain where the law is developed on a case by case basis, this is the kind of reasoning that is employed. The reasoning says that, look, we can't give you a kind of a tight formula that applies to in all cases, but we'll have to kind of develop it or think about it on a case by case basis. And therefore, it could be that sometimes there may be expenditure. Generally, if there's an expenditure that has an enduring benefit, that would work. But sometimes, when we look at the circumstances, this enduring benefit, even if there's an enduring benefit, it may not result in a capital expenditure. Um, um, in fact, down the line, the court says there may be cases where expenditure, even if incurred for obtaining advantage of enduring benefit, may nonetheless be on revenue account, and the test of enduring benefit may break down. It is not every advantage of enduring nature acquired by an assessee that brings the case within the principle laid down in this test. What is material to consider is the nature of the advantage in a commercial sense, and it is only where the advantage is in the capital field that the expenditure would be disallowable on an application of this test. Of course, we don't know what capital field means. We'll have to think about that a little bit more. The code continues. If the advantage consists merely in facilitating the SSA's trading operations or enabling the management and conduct of the SSA's business to be carried on more efficiently or more profitably while leaving the fixed capital untouched, the expenditure would be on revenue account, even though the advantage may endure for an indefinite future. The test of enduring benefit is therefore not a certain or conclusive test, and it cannot be applied blindly and mechanically without regard to the particular facts and circumstances of a given case. Then they go on to say that is one test. That is the famous Atherton case test. But there's another test, and if you scroll on a bit further, another test which is often applied is the one based on the distinction between fixed and circulating capital. And this test was applied by Lord Haldane in the leading case of John Smith and Son versus Moore, where the learned Lord drew the distinction between fixed capital and circulating capital in words which have almost acquired the status of a definition. And it says fixed capital is what the owner turns to profit by keeping it in his own possession, your building and your machinery, for example. Circulating capital is what he makes profit off by parting with it and letting it change masters. But again, the court says even this test sometimes breaks down because there are many forms of expenditure which do not fall easily within these two categories. And the line is difficult to draw. Um, there may be cases where expenditure, though related to or in connection with fixed capital, is nevertheless allowable as revenue expenditure. And an illustrative example would be of expenditure incurred in preserving or maintaining capital assets. This test, therefore, is clearly not one of universal application, right? And then they go on to talk about other cases. So you notice that there are different cases. There is a fixed capital versus a circulating capital test, and then there is a test of enduring advantage. But these are all tests that have to be applied on a case-to-case basis, and one can't give a definitive answer beforehand. What is important, these cases say in an enigmatic sense that it is should be related to the capital of the company, but that really is not a very definite marker for us, as we can see. After having said all this, the ITO versus Smartcom Technologies case said, and this is the Gujarat High Court case, as I said, that in this particular case, this non-compete agreement was revenue expenditure. So therefore, they've gone against what Sharp Business Systems and Ingersoll have said. The Smartcom Technologies case is actually going the other side, and that's the kind of interesting thing that I wanted you to think about. Right. So I'm going to stop here, and I'm going to see if there are any questions, comments, anything that you've understood or not understood from this. What's the takeaway for us? There are takeaway at different levels. Let's put it this way: that there are takeaway at different levels from this case, right? Um, at a more particular level, the takeaway is that this distinction between capital and revenue, while it turns on phrases such as to acquire an asset or an enduring advantage for the trade, or the difference between fixed capital and circulating capital, those suggest um, kind of rough and ready tests and not definitive formulas. Um, what does it say about the application of law to facts? Well, there are some domains, and even though tax law is a very technical subject, even tax law is one such domain where certain tests have to be really applied on a case to case basis, and it'll be very difficult for us to say beforehand that this is going to be the result of the application of this test. It all will depend quite on the way the facts have been set out. So that, I think, is the lesson that we have from so far from this. The nature of the test is such that is difficult to say with any kind of certainty how to apply this test. It's a very fact-based, case-by-case way of making the distinction between revenue expenditure and capital expenditure. Okay, great. I'm just going to check once more. Anything that you people want to chat about? Don't think so. Don't think I've got anybody saying anything. I don't think anybody has raised their hands either. Right. Okay, good. Okay, so we'll get back to our case. So the next case is called the Hudson Agro Products versus Joint Commission of Income Tax case, and this is a Madras High Court case. So we have gone through the Delhi High Court, we have gone through the Gujarat High Court, and now we are coming through the Madras High Court case. So you can see how there's such a divergence of opinion between different cases in this area, and I think that's a function that different high courts are dealing with it in different cases. We've gone through the Delhi High Court, the Karnataka High Court, the Gujarat High Court, and now we come to the Madras High Court, right? And the Madras High Court case is again a case of the same sort, which is that it is talking about a non-compete agreement. And it's an interesting case because here there were some founders of a company, and that company was making a good amount of money. It's a profitable company, and they wanted to go public. And when they wanted to go public, the question was, how will the company ensure that it remains profitable? And so they wanted to hedge their bets, and they wanted to make sure that the founders don't compete with the company's business. And so they entered into a founders of the company. So they entered into a non-compete agreement with the founders. And the question then was whether the payment made to these founders were capital expenditure, revenue expenditure, right? So this is note 24, and I'm just going to read out that note for you. So the SSC is a company engaged in the business of manufacture, marketing, and distribution of ice cream and dairy-based products. They started out as a partnership firm, and then it was converted into a private limited company. And then the question, it was going to be converted from a private limited company to a public limited company. And the individuals had nurtured the business from inception and continued their association with the entity over the years. Intellectual property had been developed by them, and the brand name Arun, so you are aware of Arun ice cream, has been transferred by the founder to the company in April of 1987. Now, the individuals were highly experienced in the business of dairy-based frozen food products. The appellant thus wanted to ensure that the association, appellant is the company here, the appellant thus wanted to ensure that the association with the individuals continued both in the public eye as well as in its own interests, seeing that the appellant had benefited greatly from their services over the years. Accordingly, it entered into agreements for non-competition with the two individuals, restraining them from carrying on for 20 years any competing trade, business, or activity in connection with the manufacture of ice creams or dairy products. And this is the clause that says that the party of the first part agrees that during the currency of the agreement, the party of the first part shall not directly or indirectly, without the prior consent in writing of the party of the second part, manufacture or market or deal in ice creams anywhere in the world, either by himself or in association with other or others, nor shall he involve himself in such manufacturing and marketing of ice creams, either as an employee, agent, representative, or through the medium of a company, partnership, or association of persons, or any other form. Right? And so an expenditure of 400 lakhs, 4 crores, were incurred on non-compete fee and was claimed as expenditure, right? And here the court says the question before us is the categorization of expenditure of non-compete fees as either capital or revenue. And the distinction is fine. The courts have over time evolved various tests to determine such categorization, but there's no straitjacket method and the application of the test would vary upon the facts of the case in hand. In the present case, while neither the assessing officer nor the tribunal dispute the long association and valuable service rendered by the individuals, as well as the importance of retaining these advantages, particularly at the time when it is going public, both officers deny the claim based solely on the fact that the payment results in an enduring benefit, right? And then they discuss the case, discuss case law, and some of this case law has been discussed in the previous judgment as well. And they so that case law we have already seen, and then they say the court says that's the Madras High Court in this case says, thus the test of enduring benefit cannot be applied blindly without regard to the facts and circumstances that arise in the given case. We find that the conclusion of the tribunal that the payment has an enduring benefit and is capital nature does not take into account the commercial benefit received by the company. The advantage of restraining the individuals from engaging in competition is in the field of facilitating its own business and rendering it more profitable. Since there's no increase in fixed capital, a fixed capital means the kind of the source of profits. It's not circulating. You're making profits by using this asset rather than by selling that asset. Since there is no increase in fixed capital, the payment does not encroach in the capital field. The payment made towards restrictive covenants ensure the continued presence and support of the individuals in its business operations. Equally importantly, it ensured credibility in public perception and reassured potential investors that the performance of the company would remain optimum through this continued association. And though there was no actual or impending threat of the directors severing their ties with the company or starting competing businesses, the possibility was always real, and prudence dictates that the company protects itself against such a probability. This assumed particular significance at a time when the company was proposing to go public, and it thus becomes vital that the public continue to see the company as associated with and has the benefits of services and loyalty of the individuals who has been and were continuing to be fundamental to the growth of the company, right? And and so they said this revenue expenditure. In fact, they said the judgment cited by the revenue turn on differing facts and therefore do not support its case. In fact, the Supreme Court in CIT versus Coal Shipments Private Limited, relied on by the SSC, has stated that the question as to whether an expenditure is revenue or not has to be seen from the context of an expenditure forming part of the cost of the income earning machine or structure, as opposed to the cost of performing the income earning operations. In the light of the above discussion, we hold that the payment towards non-compete fee to the founders constitute revenue expenditure in the hands of the appellant. So, interesting case. We have seen now, just to sum up the discussion of all the cases that we have done so far, we noticed that people have taken different approaches to the case. In some cases, they have said that it is a non-compete fee, expenditure on a non-compete fee is capital expenditure and is not deductible under the Act. In some cases, they have said it is capital expenditure, but it is deductible as depreciation under the Act. In other cases, they have said it is revenue expenditure and is deductible under the Act. And of course, one thing you must remember, though, is that there's a little bit of a complexity here as well, which is that in this case, in the SmartChem case, if you go back to note 23, and you notice in the first paragraph, what they've done is that in the books of account, this is the income tax officer versus SmartChem Technologies case, which is a case where there was a non-compete payment, which was then allowed as revenue expenditure by the Gujarat High Court. But what the SSC did in that case was that the SSC paid a lump sum of 6 crores as a non-compete fee, and but in the end, he wrote off one-fifth of the expenditure for accounting purposes. But in computation of income furnished along with the return, the SEC claimed whole of the expenditure of 6 crores. And so for accounting purposes he was only deducting one-fifth of it, but for tax purposes he didn't do that. He had deducted the whole amount, and so that's another interesting thing, that the accounting treatment and the tax treatment that the SSC did was different. um, and so there could be another issue there, though, so you must be careful about that as well. The one scenario is it's capital expenditure and there's no depreciation. The other scenario is it's capital expenditure and there is depreciation. Another scenario is that it is revenue expenditure and completely deductible. And another scenario is that it is revenue expenditure, but it is not completely deductible in the year in which it is incurred, but it's kind of progressively deductible over the next few years. So there are lots of variations in the tax treatment of non-compete payments, and there is no finality in this respect here at the in our courts. The Supreme Court has not yet taken a final view on how to approach non-compete fee payments and the tax treatment of non-compete fee payments. You can see a lot of different approaches going on here, including in the last case, in the Hudson Agro case. You have a huge payment, 4 crores being made to the founders, and after doing that, the courts have said that it is revenue expenditure, right? So that's an interesting set of cases not agreeing with each other at various levels, and I think we won't reach any finality until the Supreme Court decides on what to do. Yeah, so that's where we are. Before I move on to the next stage, any questions, comments? Oh, I see some chats. Okay, here it is. Here it is. So Nancy has said that here, the two individuals have been basically paid to retain their goodwill as per the facts and circumstances and intention of the payments. Um, Retain their goodwill. Okay, but Nancy, why did any reason why you mentioned that? Why is that? Why is that pertinent? Why did you mention the goodwill point? It still is a non-compete payment, though, no? So
So, may
are you
I?
sure? Of course, yeah. Yes, please.
Um, while you were reading the note, there was
Mm,
a point wherein they said that they wanted to maintain their image in front of the public as well, that they
mm,
are still in association with those two founders
mm,
who built the business.
mm,
And if the public knows that they are in still in association with these two people, the public will in some ways have more trust in their company
mm-hmm.
even after going public.
Right.
That is kind of taking the advantage of their goodwill,
The goodwill of the founders.
of the founders who built the business.
Okay. Okay.
So
Go on. Mm.
maybe that is the reason that the court is analyzing it as a revenue expenditure, because in a way goodwill will not be considered under intangible assets.
It may not be considered as under intangible asset for purpose of depreciation, you mean?
Yes, for the purpose of depreciation.
Okay, but that may be a different question, no? The prior question to that is whether it's revenue or capital expenditure in the first place. Once we address that question, then we come to the depreciation question.
Okay, sir, understood. It
Mm.
was just a thought that struck my
Sure,
mind.
sure, sure. Thank you,
Thank
Nancy.
you.
Great, thank you. So let's now. Okay, so now this is what I want you people to do. Of course, I want you to think a little bit more about the distinctions, but I don't want you to now think about these distinctions by in an abstract way. I want you to think about these distinctions that we have just now mentioned between capital expenditure and revenue expenditure through a problem. And I'm going to give you this problem here. This is a problem that we have given to our students in other contexts, our law students at NLS in other contexts. I want you to read this problem very carefully. This will take you a little bit of time to understand, right? And then apply the tests we have been talking about, all those four cases that we've done so far. Look at those tests again, look at the notes that I've given you again carefully, read through the cases carefully, and tell me how you will apply that to the problem that we have got here. Right? So this is a very different, this has nothing to do with non-compete. This is a very different set of facts. But the issues we have been discussing, the case notes we have been discussing, are relevant for your understanding of this problem. So I'll give you 15 minutes. What I This is what I want you to do. I want you to go through the case note I've given you in your course materials very carefully. We've discussed it already, but I want you to go through it to the tooth comb and then apply that to the facts here and see what answer you come up with. All right, 15 minutes. I'll be back. Please get started. Okay, I'm back. And who wants to answer this question? Let's read out the question first. So, under an agreement, A obtained from B, sorry, just give me a second. I don't know if this is coming up properly. Um, yeah, let's read out the facts again. Under an agreement, A obtained from B a lease of land for a period of 39 years, commencing from 1st of January 2024. Under the terms of the lease, the lessee, that is to say A, had the right to construct a new building thereupon to suit the purpose of their business. The lease deed further provided that the new construction shall, right from the commencement of the work, be the property of the lessors, and upon completion of the work of construction, the lessee will have only the right to be a tenant for a period of 39 years under the existing lease, subject to the payment of rent. The lessee shall not be entitled under any circumstances for any compensation whatsoever on account of its putting up the new construction. Acting under the lease agreement, A invested certain sums on construction, has claimed that such sums are revenue expenditure. The revenue claims that such sums are capital expenditure. Decide. Both the revenue and A have agreed that while the rental amounts per annum are low, the low rent reflects the fact that A will construct the new building at its own cost. How would you analyze it, my friends? What might be your approach? Um, yes, Nancy, please go ahead.
So, if I may,
Yes, please.
if we apply what we have read as far as these notes are concerned, the sum he has paid will be looked upon on the basis of following criteria. Let's go to ownership first. Now, if A is constructing a certain premises on B's land, the ownership still vests in B.
Mm-hmm.
The
Yes.
enduring benefit, though A has the enduring benefit for 39 years period, that is that he gets to enjoy that property for a comfortable, smooth running of the business. Still, it is for a definite period. It is not for a indefinite period. Therefore, the enduring benefit will still rest with B, who is the lesser.
Mm-hmm.
Now, since they have agreed on a low rent, in somewhat, B is kind of paying the construction cost in a indirect way. A is being substituted for the low rent he is paying in a lump sum money that he is paying as a construction cost, and
Mm-hmm.
B is getting the benefit of paying that construction cost in parts, that is by charging low rent to A.
Mm-hmm.
Now, the advantage, as we have seen in the section, the advantage A is getting is also for a definite period. So
Yep.
all of this makes it a revenue expenditure for A,
Right.
in my
Right.
understanding.
Excellent. No, Nancy, I'm really happy to get this answer from you. Your analysis, for the most part, is absolutely spot on. I'll tell you where I want to add to what you've said. But this fact situation that I've just given to the class is based on a Karnataka High Court decision. And in that decision, the High Court came to the conclusion that this would indeed be revenue expenditure for A. Uh, when I gave this to my students, the students felt that this is a very tricky case because A has actually invested on construction something, and it's going to last for a good number of years. But there are two elements here that are critical for our understanding. One of which you have already pointed out, which is that yes, there is an enduring benefit to A in the sense that it's for a number of years, as much as many as 39 years. But A doesn't own an asset at the end of it. The building goes to B, and therefore enduring benefit test refers to enduring benefit in the way a capital asset endures, right? And therefore, remember, we had discussed case law previously, and we should not look at enduring benefit or the idea of enduring benefit in a contextual sense. We should look at it in context. Here, A is getting some enduring benefit, as in that there's going to be a building available to him on construction for a number of years, probably as many as 30 years or more than that. But he doesn't own the asset, and it's not going to be a source of income for him from that sense. He will house his business in that asset, but that asset itself will not be a source of income for him, and therefore one can make a strong claim that it's not an enduring benefit in the way and a capital asset endures. That's one interesting aspect of this case that I thought I should bring to your attention. The second thing that I wanted, and this is where I wanted to add to what you was talking about, Nancy, you were right to point out the importance of focusing on the low rent, right? And I want to just finish that point that you were making, and I wanted to add to it. That's a very interesting aspect of this case, which is that the rent was lower than the market rent because the lessor already knew, the lessor and the lessee already had agreed that that is because of the fact that something is going to be constructed on that land for the benefit of the lessor. So, in other words, this the rental payment, a part of it was shaved off for that reason, right? And that to me looks like another factor that goes into the mix and is in favor of this idea of this expenditure being capital revenue expenditure, because this added expenditure by A is reducing his rent under the agreement, right? And because it's reducing its rent of the agreement, it looks to me like it's related to revenue expenditure, because rental payments are revenue expenditure. It's related to revenue expenditure rather than capital expenditure. Well, see, look at how interesting the contract is. Instead of A paying B 100 rupees per month as rent, or 100 rupees per annum as rent, A is saying, let me pay you 50 rupees per annum, and the other 50 I will just spend on some expenditure on the land, on constructing a building on the land. And so shave off, give me a discount on the rent, right? That kind of talk. So what A has basically done is he has converted part of his rental expenditure into expenditure on building on the land, right? Because he's saying, instead of me paying you 100 rupees per year, I'll pay you 50 rupees rent, and I'll use the other 50 rupees to construct something on the land to which you have ownership at the end of it. So what he has actually done is a part of the rental payment is actually being used for for this purposes, for construction purposes. It could have been this way: A could have paid all of 100 rupees to B, and then B could have used that extra 50 rupees to construct a building and own it. But A didn't do that, right? If A had paid all of 100 rupees to B, and then B had used that construction, the money to construct, from A's point of view, that expenditure of 100 rupees rent per year would definitely have been revenue expenditure, right? It so happened that they've structured their contract a bit differently. What they've done is they have said, fine, I'll pay you a lower rent, 50 rupees, and I'll use the other 50 rupees that I've saved in constructing something on the land, and which you can, you have ownership over that, right? So that's a very interesting of the way they structured the contract. But the economic effect, the court was saying, was that this is related to revenue expenditure. Great. Any questions on that? Let me just do the stop share because I want to come back to the class. We have about 4 minutes, 3 minutes left. Any questions on what's happened? Look at the cases. The case I gave, the last case that I gave you, is an interesting application of the tests that we have discussed to the facts, because the tests are saying enduring benefit, but what does that mean in when you apply? And you notice here that sometimes we look at a long-term contract under which there is some enduring benefit, but then we still try to figure out what is the true nature of that contract. And the true nature of the contract is that some part of the rental payments are being used to construct, and that construction will be for the benefit not of the person making the payment, but of the person receiving the payment, and therefore it would be revenue expenditure. All right. Any questions so far on what we have done here? Any questions or comments? Okay. So thank you very much. Next week, we'll start with another very interesting item of taxation called the taxation of capital gains under the head capital gains, and we'll see a lot of very interesting case law in that area. So have a nice weekend, all of you, and see you. See you well. I will probably will see you next Thursday. So it's not next Saturday, it's next Thursday. All right. Thank you very much, all of you. Take care. Bye. Have a nice weekend.